Good morning, Judge Turner. How are you doing this morning?
I'm doing all right. How are you?
I'm good. Not to jump in, I just noticed Mr. Zell is online as one of the attendees. He's handling the Baker case and the Johnson case. And we have, I think, all three witnesses in his two cases. The one witness we don't have is in that the other case that I had asked that we call first. So I don't know if we want to proceed with the ones Mr. Zell is in. I think they brought Mr. Bell in. His former attorney's supposed to be appearing, but we haven't seen him yet. But I'm just apprising the court of who's here.
Okay, well, let's proceed with what we have, and maybe everybody else will join in at some time. Does that sound okay? Didn't you say we had some people who were ready?
I believe so, Your Honor. We just need to swap out the inmates.
Okay, can we do that, please?
And I'll let Mr. Zell, he's online. Good morning, Mr. Zell.
Good morning, Ms. Smith. How are you doing?
Good.
Good morning, Judge Turner. Yes, Your Honor, I have two cases. One is Sebastian Johnson, and I believe, and I have subpoenaed trial counsel. I've sent him the link. I don't see him logged in. The other case I have is Ramon Baker. And I subpoenaed trial counsel. We already took the testimony of appellate counsel. Trial counsel has a conflict. There's witness for Mr. They're the two witnesses for Mr. Johnson.
Okay.
As far as Mr. Baker goes, his attorney had a conflict, but he was going to be available. Just don't know quite when. He had a court appearance, I believe, at 9 o'clock, and he was going to be available for that. The only other thing I would add about Mr. Baker, and Ms. Smith, I don't know if you have any input. Since we heard part of this hearing with Judge Rose, is there any issue with two judges who are here in different parts of the hearing? I don't know if this is something that.
Not with us. And I think Mr. Garner may have called in. I have him listed as an attendee, but I'm IT challenged, so I don't know but yeah, we don't have any problem with Judge Turner hearing the rest of the Baker case.
All right. So I guess then is Mr. Johnson here online?
Online, do you need for me to get him, switch the inmates out?
Okay.
I don't see Mr. Garner, so.
But under attendees, if you look at attendees, it looks like he's checked in, or unless he's just listed.
I see that. I do see that.
Mr. Garner is here.
He is, okay.
Yeah, Mr. Garner is. What we do is once the case is called, we'll transfer him over so that's to limit the amount of open feeds and allow the judge to focus on the ones that are actually being heard. So once that case is called, we'll move him over.
All right, what case are we calling first then?
Sebastian Johnson, Smith State Prison. Will you have Mr. Sebastian Johnson?
Okay, sure, hold on a moment.
Are you Mr. Sebastian Johnson?
Yes, sir.
All right, can you hear me?
Yes, sir. Yes, sir.
All right, if you have any trouble hearing anybody, let us know. That's,
All right.
I don't know how you would let us know if you can't hear, but we need to make sure that everybody is able to be heard today. I just wanted to make sure you could hear me. All right, we're calling your case, Mr. Johnson. You folks ready?
Yes. Yes, sir.
All right, you proceed.
All right, Your Honor, I'm representing Mr. Johnson. My name is Rodney Zell. Please the court, I'm representing Mr. Johnson for his habeas corpus. Mr. Johnson filed his habeas corpus pro se on October 12th, 2018. He raised a number of grounds. He was convicted in Cobb County of 2 counts of armed robbery. And after jury trial, he was convicted. He was represented by Mr. Rick Christian, who's here, and on appeal by Stephen Scarborough, who's here as well. I came into the and then did amend the petition. What I did was going through each ground, I withdrew ground number 1 of his pro se petition. I withdrew ground number 2 of his pro se petition. I amended his ground 3. I withdrew ground 4, and I added grounds 5 through 8. Other than that, I can just go ahead and go through each ground, go ahead and call each of the attorneys and go ahead and proceed with the case and examine them about these issues, if that's all right with Your Honor, unless Ms. Smith has something to add.
That's fine with me. Smith, do you wish to make any opening?
No, Your Honor, I don't.
Okay. Well, let's go ahead with your examination then, please.
Does anybody want to invoke the rule with Mr. Christian and Mr. Scarborough here, both testifying?
Ms. Smith?
Okay.
I'm sorry, I don't.
The court does not know.
Okay, I'll start with Mr. Christian, if you don't mind raising your hand, please. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, and if you could state your name, please.
Rick Christian.
And what is your occupation?
I'm a defense attorney.
How long have you been an attorney?
23 years now.
And are 23 years licensed in the state of Georgia?
Yes, sir.
And in those 23 years, you've been strictly a criminal defense attorney?
Yes, sir. Yes, sir.
And have you tried felony cases previous to the Mr. Johnson's case?
Yes, sir.
Do you recall if you were appointed or represented to Mr. Johnson?
I was appointed.
Do you remember at what stage of the proceedings, i.e. the bond here, shortly after arrest, after indictment?
I would have been appointed shortly after arrest.
Okay, all right. And do you recall when the case was tried?
I don't know when it was tried, but I remember the trial.
Okay, all right. Now, going back, if this was 2011, would that sound reasonable?
Yes.
Trial?
Yeah.
Okay, so it was a fairly old trial.
Yes.
At that time, had you had other armed robbery trials?
Yes. Yeah.
Do you recall whether or not you engaged in reciprocal discovery with the state?
We did.
Did you receive discovery?
Yes.
Did you review discovery?
Yes. Yep.
Did you review the case with Mr. Johnson?
Yes. Yes.
Okay. Do you recall whether or not he was ever released on bond, or was he incarcerated during the time of leading up to the trial?
He was incarcerated the entire time.
You recall whether or not you ever visited him in the Cobb Jail detention center?
Yes. Yeah.
Okay. Did you go over did you develop any kind of defense strategy for the case?
Yes.
Okay. And do you recall what that strategy was?
Just misidentification. There was 2 counts, I think, where the victim said they were 80% sure that was Mr. Johnson. Then I think there was 2 others that said it was Mr. Johnson, but there was we had some argument with his hair and whether or not he had dyed gold or blonde tips on the end of his dreads.
Okay, so let's go back, and since you mentioned that, So do you recall the indictment?
Yes. Yeah.
And the indictment was 8 counts of armed robbery.
It was more than that went to trial, but yeah, I think actually we went to trial on 4 counts of armed robbery.
Were these armed robberies committed all on the same day?
That I don't remember that.
Okay. Were they all the same incident or different incidents?
Oh, yeah. There was. I don't remember what the state null crossed up front before the trial, but yeah, there was 2 victims of an armed robbery, and then at another location there was 2 more victims of an armed robbery. So basically, there was four alleged victims on 2 different incidences, but I don't remember the time frame between the 2 incidences.
Okay. So you mentioned 2 and 2, and I'd asked you about 8 counts. So what happened with the other 4 counts?
I honestly, I can't remember if it was ag assault and armed robbery, but if it was just 4 counts of armed robbery, Lynn Volker, the DA, called me that Saturday, the Saturday before trial, and gosh, we were on the phone for probably 2 hours, and she had talked to the witnesses of the counts that were no pros that morning, and I didn't understand her reasoning, but she said she was going to null pros them Monday morning, so not to prepare for those and not to get ready on those counts.
Okay. So there were 4 counts that were dismissed, I guess, would you say, I guess, on the eve of trial, so to speak?
Yeah, and like I said, she explained it to me, but I don't know why she didn't go forward on them just to see what the jury would say, but I don't know. I got the impression there was something going on with the victims and she didn't want to call them, but I didn't, like I said, I didn't agree with it, but she said, "Hey, I'm dismissing 4 counts." And I was like, "Well, there you go. I'd rather try, 4 than 8."
When you say you didn't agree with it, what is that? What do you mean by that?
I didn't understand her reasoning.
Okay.
Like she said she met with the victims and she was just going to dismiss those counts. And I honestly, I can't even remember what it was, but I was happy that we were going on 4, not 8, but I didn't understand why she just didn't throw it up and see what they said. I mean, maybe the victims were in jail. I don't know, but it was that Saturday she decided that she was going to null pros those 4 counts Monday morning before trial.
Okay. Do you recall, had Mr. Johnson been previously identified as the defendant in those cases? I mean, he was indicted, so I guess that would be kind of fair to say, right?
Yeah, and it didn't even have anything to do with the other 2 counts. I had something to do, I think, with like an attempted carjacking or something. It didn't like fit the MO, and it kind of came out of, left field of where these charges came from. But I think they did ID Mr. Johnson. But like I said, something happened with her and the victims that Saturday morning, and she just said she was going to dismiss them.
And if I misspoke and said 4 counts of armed robbery and when it was really 2 counts of armed robbery and 2 counts of kidnapping, does that refresh your memory at all?
Yeah, I think that would go along with the car incident, like taking them out of the car at gunpoint or something. Like I said, I was really focusing on the 4 armed robberies because there was, ID and lineups and all that. And I remember what I was doing. I was tied up that Saturday morning when she called. So, I was going to spend Saturday and Sunday getting ready for those first 4 counts when she called and said, "Don't worry about it. I'm just going to no props those."
Okay. So with the 4 counts that did proceed to trial, the defense was misidentification?
Yes. Yeah.
Okay. And ultimately, did that argument work? Or did that defense work?
Yeah, I mean, on the two not guilties, the victims wrote 80% or 80% sure on the ID card. So obviously I argued that, and those are the ones he was found not guilty on. And then the 2 that he was found guilty on, I think the argument was just coming down to, the gold tips or dyed tips on his dreadlocks. And I mean, not long dreadlocks. They were maybe, I can't remember now, maybe 6-7 inches long. So I was just arguing, I had mentioned like, cross race identification and the DA kind of yelled at the judge that I had presented an expert on that theory. But yeah, just the dreads didn't match, the tie-dye tips didn't match.
Okay. So starting with 8 counts, 4 were dismissed by the state, 2 were not guilties, and 2 were guilty?
Yes, sir.
Okay. And of the 2 that were guilty, you kind of testified regarding some of the misidentification issues. Of those 2 armed robbery counts, do you recall whether or not both or one or none identified Mr. Johnson as the perpetrator?
Honestly, I don't remember, but I mean, they would have put his picture in a lineup and they would have picked him out. I mean, it wasn't anything dealing with the 2 counts that were not guilty. It's, you know what I mean? It's not like they said he ran that way, and so they used the ID on the first 2 to make the ID on the second 2. I think it was a completely separate incident. And I think they put him in a photo lineup, and the victims picked him out.
Okay. Now, regarding the 4 counts that were dismissed, do you recall that you testified? You recall that Mr. Volker, the prosecutor, and dismissed him, and you don't recall the specific reason?
No, it had something to do with the victims. Like I mean, they could have been in jail. They could have been drug addicts. They could have, I don't. It had something specifically to do with the victims, and like I said, I was grateful that she was just walking away from those 4. I didn't think that there was enough for her just to no process and walk away, but she did. So I was grateful for that.
Do you recall whether or not for those 4 that Mr. Johnson had an airtight alibi?
No, I don't remember that.
Okay. Okay. Now, did you consider, now, since misidentification was your sole defense, would that be fair to say it was your sole defense?
Yes. Yeah.
Okay. So at some point, it seems reasonable that Mr. Johnson was identified in the 6 counts for which he was not convicted. Is that correct?
Yes. Yeah.
Did you consider when Ms. Volker said she was going to null pros, objecting to the null pros, saying, "Hey, we want the jury to hear you guys kind of screwed this up too? You screwed up this identification as well?"
No, I didn't. No, I didn't. I mean, the less the jury knows about a defendant, I didn't. I thought it was better that we just went on the 4.
Okay. Well, let's go with this, that when there's a situation in which there's an airtight alibi and there's no doubt that it can't be the defendant, does that not go into the support your defense?
I mean, I guess you can look at it either way. I mean, 4 counts are going away. So that's less that the jury's going to think, bad of your client, so to speak. But I see what you're saying. You could let those 4 in and then put up a defense and see if they find them not guilty of those 4 counts.
Well, your premise is based on that Ms. Volker thought maybe the victims had some issues. So if that's
Your Honor, I object to this line of questioning. The null pros order has a specific reason given, and we're getting into a lot of speculation.
I agree. I'll sustain the objection. Let's move on.
Okay.
The non-parks order, it was explained to me just now, states specifically why it was non-parks. Is that correct?
I'm sorry, I can't hear, Your Honor.
The non-pros order states specifically on its face why the non-pros was entered. Is that correct?
Yes, Your Honor. It does. We'll be tendering that.
Okay.
Or I can share that with the court now.
Please share it now.
It says, and I quote, "Because of conflicting and inconsistent statements made by the victims and the responding officer, the state is unable to prove defendant's identity beyond a reasonable doubt in these counts." It's the last paragraph.
So it's an identity thing that was stated in the non-pros order. All right.
it doesn't, she doesn't reference identification. She just says conflicting statements. She
Yeah.
couldn't prove, and the officer as well, the victims and the officer.
All right, okay. All right. Continue, please.
Okay.
But not down that particular rabbit hole.
Okay, if Your Honor can just give me 1 second, I'm going to pull up a transcript here.
Sure.
Okay. I'm going to see if I can share this to see if this refreshes Mr. Christian's memory at all.
All right.
Okay. So this is volume 1 of very first day of the trial on line 8. If you could see if that refreshes your recollection at all. See that, Mr. Christian?
Sorry, yes, I can see it.
Okay.
It took up my whole screen. I couldn't get off of mute.
Oh, I'm sorry. Okay.
No, it's fine.
Let me know when you're done.
Okay, yeah, I see it.
Okay. Does that at all refresh your recollection as to any specific reasons why the state null pros those charges?
Yes.
Okay. And do you remember anything specifically now about that? I'm going to stop the share here. Let me get to this and stop sharing. Okay. All right. I'm sorry. Go ahead.
Yeah, so I mean, like, I don't remember exactly what she said about it, but looking at that, it was the identification.
Okay. And does that at all refresh your recollection as to whether or not Mr. Johnson had any kind of alibi for that incident?
Honestly, I do not remember that.
All right, that's fine. Okay. Let me move on here then. Now, before I do, though, let me ask you, have you had other trials in which you've had multiple incidents charged within the same indictment?
Yes.
Yeah. Okay. In those situations, have you, as part of been your defense to show, hey, one of these incidents, the evidence is weaker, so therefore you can't kind of trust the evidence in the other incident?
Yes.
Is that a reasonable strategy in trials?
Yes. I mean, it's, I tried a case where the ID was 100%, the incident was 5%. Then in the other one, the incident was 100%, the ID was 5%. The jury convicted the guy of everything, kind of crisscrossing, like, well, this isn't really even an attempted rape, but the other one was a definite rape, but she didn't ID him. Yeah, I've tried, with multiple instances and a mishmash of it's a good, offense versus a bad ID.
Would in those situations, is it fair to say that the stronger the defense is in one instance, the more likely that defense would work, as opposed to the weaker it is, it wouldn't? Does that make sense?
I mean, yeah, I mean, you would think so, but, you know, a lot of times the juries don't. I mean, I've tried probably 4 serial rapists where every incident had a completely different ID versus was that an attempted rape? And yeah, the state crisscrosses, since this was, absolutely a rape, then obviously the same guy attempted it this time. And that girl that was raped is kind of scared and, didn't remember the face. But in the other one, the girl actually knew the guy. And it doesn't, I mean, I've never had any success with that.
Okay. So this case would be a little different from those, correct? Because it doesn't involve the absolutes like it's I think you've already testified that one of the victims was, I think, would you say 80% sure?
Yeah, they actually wrote it on the ID, the lineup, where they signed saying this is the person. They wrote 80% sure. So, I mean, he was found not guilty on those 2 counts. So we had a good argument on those.
Okay. So would it be fair to say that the weaker the ID is, and the stronger the defense is in the other, and another incident would make that a better defense?
I mean, I would think so. I mean, obviously, if you have that, but I think on this one, if I'm not mistaken, the 2 victims on the one that he was convicted of said, 100% that's him.
All right. Now moving on. Do you the armed robberies for which Mr. Johnson was convicted, counts 7 and 8? Do you recall the basic facts of those?
No, I don't. I think one was a guy walked up, asked for a cigarette, and then pulled out a gun. I don't remember which one that was. But I do know that there was some argument from the state that, Hispanics are, the common target for armed robberies because A, they may not be here legally, and B, they don't speak English, and C, they don't like to go to court. So they're targeted, and I think in this case, all 4 victims were Mexican.
Okay. So now, do you recall what property, if any, was taken?
I do not.
For which he was convicted?
Yeah, I don't remember.
Let's see if I can refresh your memory here. Okay, let's see. This is volume 2, page 124. Share. Line 3, starting line 1 was your question, or was the state's question?
Okay, so yeah, nothing was taken.
Okay. Did you consider asking for any lesser charges on attempted armed robbery?
No.
Okay. Do you recall whether or not you discussed that with Mr. Johnson at all?
I'm sorry, you broke up there for a second.
Do you recall whether or not you discussed that with Mr. Johnson at all?
Asking for what, like a robbery?
Yes, or attempted robbery, or attempted armed robbery.
No, I mean, I think it was just, no, I don't remember talking about a lesser included. I mean, our argument was it wasn't him.
Okay. Do you ever argue alternative defenses in the case?
I mean, if the facts support it, I remember a long time ago I did a trial where the guy said there was a gun. The robber was caught like 15 seconds after the armed robbery because there was a police officer right down, driving by. They never found a gun, so we argued a robbery on that one. But the police even, admitted he was caught immediately and there was no gun. So I in that one, yeah, we argued robbery.
Okay. Now, there's something that I think you do remember, and that is in the closing argument, there was some type of argument about odds and percentages. Do you recall that?
No, I don't remember that.
You don't? Okay, I thought you did. Okay, all right. So I'm going to see if this refreshes your memory as to that. Let's see.
I mean, I was arguing 80%, that I'm 80% sure this is the guy on the two that were not guilty, but I don't think there was an argument on the other two of any percentage.
Okay, here we go. This is the volume 3, page 271 of the state's closing argument. Is that showing up on my screen? This transcript?
Yes.
Line 8? Okay.
Yes.
Going down to line 21.
Okay, yeah, I see that.
Okay. So, listen, I'm no mathematician, and I seriously doubt the prosecutor is either, but in any event, he told the jury that it's a 2% chance that, basically 2% chance of misidentification.
Correct.
Okay. Do you recall that? I mean, do you recall that at all during the closing argument?
I do not.
You don't recall anybody testifying, any mathematicians or statisticians testifying during the trial, do you?
Oh, no.
Okay. Have you, I suppose if a statistician or mathematician had testified regarding the odds of misidentification, do you think you would have, is that something that you would normally object to?
I mean, if she's just arguing something the jurors can do themselves, I don't know that I would object to it.
All right, but I mean, again, is Ms. Volker a mathematician to your knowledge? Is she a statistician?
Not that I'm aware of, no, sir.
Are you aware whether or not this is even an accurate determination of odds and statistics and how to arrive at odds of a misidentification?
No, I'm not. No.
I mean, does this even take into account other factors of identification? Of other than just I'm going to characterize it as guesswork. I don't know. I don't even know what it is, but do you know if this is even accurate at all yourself?
No, I do not.
Okay. And do you recall whether or not any jurors were mathematicians or statisticians?
Oh, geez, no.
And I'll go back to the original question I actually asked was if a prosecutor, if a prosecutor were to tender I guess an expert on odds and misidentification, well, has that ever happened in a trial of yours? Has a prosecutor ever
No.
tried to? No. Is that something that you believe you would object to normally?
I object, Judge. This whole line calls for speculation. That's not what happened in this case.
It does call for speculation. Apparently, she made the argument, and no objection was made, so I assume, Mr. Zell, that's your argument.
That is, Your Honor.
All right, let's move on then.
I'm going to stop sharing here.
You're muted.
Okay. Do you recall a witness named Detective Johnny, I'm going to say Mueller, Moeller, and Johnny is Jonnie?
No, I'm not familiar with that name.
Okay. Do you recall who the lead investigator in the case was?
I do not.
Okay. So I'm going to pull up the transcript again and see if that refreshes your memory. Okay, this is volume 2, page 170 going into 171. Let me share here. Okay, it's line 22. Well, maybe I can go up here and get the whole thing in here. Well, the question is on line 21, and how did you identify him as a suspect?
Yes.
Going down into 171. Okay. All right. Are you finished?
Yes, sir.
Thank you. All right. Let's see. Okay. Do you recall that testimony at all?
Yeah. I remember how they ID'd him.
All right. Do you recall whether or not you considered objecting? Is that getting into, I guess, getting into Mr. Johnson as a kind of a serial criminal here?
Well, I don't remember the backstory was, and I don't remember why, but the police just took a picture of him. He wasn't questioned. He wasn't under investigation for anything. I didn't even know they did that. They put in Sebastian's name in the Marietta police database, and it somehow, and this is strange that it was, 10, 11, 12 years ago, it pulls up every single interaction you've ever had with the police. And it popped up that the police just took a photo of them. I think we had talked about it before the trial. The state was not going to get into like how, when, or where the photo was taken. Just the police had a photo of them. It was outside. It wasn't a book-in photo. If I remember correctly, I think there was like a fence in the background and some trees or something. Like it was clearly he was, outside. And they just said they had a photo and they put it in the lineup. So I do remember thinking that was a little odd, but I don't think that there was, anything that the jurors would have culled from that it was, a prior book in or anything that would have brought Mr. Johnson's character in the question.
What about the statement that he matched the description?
I mean, I wouldn't object to that.
Okay. Even though identification was the only issue in the case?
Would you repeat that?
Even though identification was the only issue in the case?
Correct,
Okay.
yes.
Okay, all right. Let's see, I think that's all. Let me just double check. All right, that's all the questions I have. Thank you, Mr. Christian.
Ms.
Thank you.
Smith?
My excuse. Oh, sorry.
I have no questions, Your Honor, of the witness at this time.
Okay. Can we excuse the witness?
Yes, yes.
Okay.
All right,
Thank you,
Yes,
sir.
Your
Have
Honor.
a good day.
Thank you, sir. All right. Have another
Thank you.
witness?
Yeah, go ahead and call Mr. Scarborough.
Can you hear us, Mr. Scarborough?
He's on mute.
Let me see.
Can I
All
be
right.
heard now?
Yeah, I think so.
Thank you. Please pardon my earpiece. I'm using a Bluetooth to be heard.
That's fine. You've been called as a witness. Raise your right hand for me, please. The evidence you give is sworn or affirmed to be the truth, so help you God.
I do.
All right, thank you.
Yes, sir.
All right, will you state your name, please?
Stephen Scarborough.
And Mr. Scarborough, can you tell us your occupation?
Yes, I'm a criminal defense attorney.
And how long have you been a criminal defense attorney?
30 years a week ago Saturday.
Okay, congratulations. And you've survived. So how long, you said criminal defense, has that been for 30 years, criminal defense, 100%?
Most of it. I worked in a civil rights law firm for 5 years, about 20 years ago. But other than that, I've been in criminal defense.
Okay. And in that capacity, have you handled appeals?
Yes.
Okay. Have you handled a number of appeals?
Yes, that's been my primary work, although I have done trial work as well.
Okay. All right. Now, do you recall representing Sebastian Johnson?
I do.
And do you remember, were you appointed or retained?
This was a retained case. I was in private practice at the time.
Okay. And do you remember at what stage you were appointed? Was it shortly after verdict, or really primarily, was it before the motion for new trial or after the motion for new trial?
It was before. I handled the motion for new trial as well as the appeal.
Okay. And do you remember just generally what you did when you were retained to get the case?
Yes, I had several conversations with Mr. Johnson's very sweet mother. I reviewed the transcript and the discovery in the case. Met with Mr. Johnson also, I think at least once, although it's been a long time, and did some research and put together my claims for the amended motion.
Okay. Do you recall whether or not you talked to Mr. Christian about some of the issues?
I did.
And did you raise ineffective assistance of trial counsel?
I did.
And did he testify at the motion for new trial hearing?
Yes.
Do you recall the issues you raised on appeal?
Generally, yes. I reviewed my appellate brief briefly yesterday.
Okay. And what issues did you raise on appeal?
The main theme of the appeal, as I recall it, was that, well, there were two things. One is that I thought Mr. Christian had created more problems than he solved with some of his cross-examination. For example, it was an identification case, and it seemed to me that at least in one instance, and I believe it was the counts for which Mr. Johnson was convicted, there was a weak ID, and unfortunately, it seemed to me that Mr. Christian's cross-examination of the victim or complaining witness actually tended to sort of bolster the ID. So I was concerned about that. Another thing that was that there was very extensive testimony by the lead detective in the case, which was an awful lot of talk about police methods and how thorough they were, and also about sort of a crime wave happening in the area of Cobb County where the robbery occurred. And to me, it seemed that a lot of this tended to bolster the state's case improperly. You know, the detective would talk about, you know, a crime wave or a rash of crime, and also would talk about various investigative techniques in a way that I thought sort of implicitly brought in either hearsay or allegations of crimes to which there was no link to Mr. Johnson. And I thought that had been unfair and could have been curtailed had there been a proper objection. And Mr. Christian, as I recall, did not object at all to any of that testimony.
Okay. Now, along those lines, the last issue you talked about, you raised, did you hear the question about about when the detective testified about the crime in the area on page 170 to 171?
I believe so.
Okay. Do you recall if that's something you included?
I'm sorry, could you show that again?
Show you the transcript pages?
If it's available, yeah.
Yeah, it is. Yeah. 1 second. Okay.
Yeah, I don't recall whether I raised this particular instance in the record, but that testimony that you pointed me to at 170 and 171 is certainly has the flavor of things that I was concerned about. Specifically, there was talk about investigations and maybe compiling a list of people who'd had other problems, and I just thought that that general kind of testimony was prejudicial.
Okay. Do you have your appellate brief in front of you?
Yes. Oh, okay. Yes, I did a search for the page number, that 170, and actually the exact passage you were pointing me to is mentioned in my statement of facts on page 11 of my appellate brief.
Okay. And the issue you raised regarding I guess that would be Johnny Mueller, the lead
Yes.
investigator. That was the issue number one in your case?
Yes, I believe that was my first issue. Yes. The way I framed it was a lot of testimony, quote, explaining police conduct. And I cited a Georgia Supreme Court case that suggested that explanations of police conduct are often not relevant.
Okay. Now, in the actual issue, I don't see. Did you point out any specific factual allegations in the specific issue?
In the argument?
Yeah, issue number one in the enumeration of error.
Let's see. I think what I did, I think the statement of facts in this brief was kind of more full of block quotes and extensive quotations than one would normally like to have, because nobody likes to read those. But I actually did quote a good bit of that testimony in this brief. And then I think my approach was in the argument section to refer broadly to those things as sort of a type of testimony that was recurring. I may not have, and I don't see immediately right now that I did particularly argue that passage. I was instead summarizing it in the earlier part of the brief and then kind of talking about it broadly in my argument section.
Okay. Now, did you argue insufficiency of the evidence?
I did not.
Did you ever consider whether or not there was no armed robbery based on no property being taken?
Well, I don't think I did. I saw that you had alleged that, and my recollection was that there was a wallet taken. I acknowledge it was not retained, and so, but I can't say, sitting here years later, that I remember ever considering it a mere attempt.
Okay. All right. And what about, in that vein, what about whether or not you consider raising that Mr. Christian should have asked for a lesser charge of an attempt?
Same reasoning. I don't think it really occurred to me. I may have failed to consider that.
Okay. Do you recall if you talked to Mr. Christian about that at all?
I don't think I would have raised that with him in particular because, maybe I wasn't careful enough. But in my mind, I seem to recall treating the case as I worked on it as a completed robbery.
Okay. All right. And I think that brings us to the last. Well, one other thing. What about, do you recall any issue about the dismissal of the middle four counts of the indictment, the null pros?
I remember that at some very early point in the trial, I don't remember if it was before jury selection or before the first witness or whatever, but I do remember that there was, that some counts were null pros. And I believe from my review yesterday, there was a trial indictment that was used that had redacted out those counts, but made it look like an 8-count indictment rather than a 12. Because that was done, I don't think it occurred to me that there would have been any prejudice arising from the existence of those other counts. Had there been just a scratch through where the jury could have still seen the dismissed counts, that would have raised a red flag for me. But given the way it was handled, I don't think I did perceive a red flag.
Okay. Do you recall anything specific about why those 4 counts were null pros?
Well, I did hear the conversation just before when you were examining Mr. Christian, And that does comport with my recollection that Ms. Volker just didn't think she could prove those counts in terms of identification.
Okay. Did you ever consider that perhaps there should have been an objection to that, to raise that as a demonstration that the state's, not only would the jury find him not guilty of the counts 1 and 2, but look at counts 3 through 6 here. They're way off base for this too.
Well, I think to the extent that I might have considered that, I probably thought that that would have been well enough within the trial attorney's discretion that I wouldn't be able to establish ineffectiveness. However, I can't say, in fact, I don't think that I discussed this particular issue with Mr. Christian. So that was really just my assumption rather than based on anything that he said about what he had thought or not thought or done or not done.
Okay. And lastly, the argument in the closing about the odds, you did reference that, you did raise that as an issue on appeal. Is that correct?
It was, again, mentioned, certainly. I always think it's sort of outrageous when anybody tries to quantify reasonable doubt, and I thought it would catch the court's eye. What I ended up doing was including that in sort of a general enumeration of error on appeal. I did not raise it as a standalone error for reversal, but I did raise it as one of several things that I thought either shifted the burden of proof or was otherwise erroneous.
Okay. What about is just introducing evidence, like as a scientific study or something? Did you consider that?
You mean raising ineffective assistance for failure to object, or what's your question?
Yeah, the trial counsel should object on that ground. Is that was, that was really more, it could be more than just argument. It's more like a prosecutor's statement of fact. These are the odds. Therefore, there's no way Mr. Johnson can be not guilty.
Mm-hmm. Yeah, I don't think it struck me as an experiment or a mathematical demonstration or anything like that. I think what caught me about it was just sort of the general problem of trying to go beyond the pattern instruction and define reasonable doubt. And I think I also am pretty sure that I said in my brief that in addition to being improper, the calculation that the prosecutor gave in closing was just wrong. I think she came up with a much smaller chance of a mistake on the victim's part than would have been the actual answer if mathematics there were permitted.
Well, I guess I would ask you how you think the jury felt when they heard a prosecutor give, state matter of fact, these are the percentages and it's less than 3%, but I know that would cause an objection, so I'll just rest there.
Very well.
Ms. Smith, do you have any questions?
Yes, Your Honor. Good morning, Mr. Scarborough.
Morning.
If I understood your testimony, you said you viewed this as a completed robbery?
Yes, I did not. I didn't reread in its entirety my brief from yesterday, but I do know that the alleged robbery was of a wallet, not of the contents thereof. And my memory now, years later, is that I was addressing it as a completed robbery.
Okay. And I think you indicated you did not challenge sufficiency of the evidence for the armed robbery. And you did review this transcript with an eye towards identifying potential issues?
Absolutely.
And you raised claims of ineffective assistance of counsel?
Yes.
And then the enumerations you raised on appeal were 4 instances of alleged ineffective assistance of counsel?
That's right.
I may have just a moment, Your Honor.
Okay.
I have no further questions at this time.
All right, thank you. Can we excuse the witness?
Yes.
Yes, Your Honor.
Mr. Zell, you have anything further?
Yes, Judge, may I have a moment to speak with Mr. Johnson before I proceed?
You may do that. While you do that, I'm going to take a short break, okay?
Thank you, Your Honor, and I'll step out.
So I think the host has to put us into, or either that or I can call the prison. Is there anybody there? Mr. Johnson, is there anybody there with you?
Yeah.
Can you give me the number to call you?
912-654.
I'm sorry, 912-654.
5045.
504. Okay, I'm calling right now. Thank you.
Okay.
Can everybody hear me?
I can.
I feel like maybe I was on mute. Can everybody hear me? I was on mute. I'm sorry. My computer itself.
Everybody back online?
Yes.
Yes, Your Honor.
Okay. I think everybody can hear you.
Okay, all right. I'm going to judge petition arrest subject to, I think Ms. Smith has the records. I won't tender mine if she's going to tender hers.
All right, Ms. Smith.
Yes, and Your Honor, Kathleen McCandless is going to perform the role of Vanna White and do the screen sharing for me. And we have as respondents one, their documents from the clerk's file, which include the indictment, sentence, motion for new trial, amended motion for new trial, and the order denying it. Kathleen, if you can try to screen share. This is the one thing that flummoxed me, Judge. I've not gotten this down yet, and I apologize.
You don't need to apologize about anything having to do with technology to me.
And you can see, Mr. Zell, this is certified.
And Ms. Smith, I don't have any objection. I've seen the clerk's file, and I know that you sent a letter of request. I've seen that as well to the Cobb County's office, so I don't have any objections to these documents. I mean, I know what the clerk provided, so I do not have any objection. If you still feel the need to screen share, if I have a question when you just tender them, that's okay with me.
Sure. Okay.
But that way you can just go through, and if there's something I'm not aware of, then I can speak up. But generally, I would say no. I have no objection.
Thank you. I appreciate the accommodation. Then Respondents 2 is volume 1 of the trial transcript. Respondents 3. I'm sorry, Judge, you want me to tender them all or you want to rule on each one?
No, you tender them all. That's fine.
Okay. Respondents 3 is volume 2 of the trial transcript. Respondents 4 is volume 3 of the trial transcript. Respondents 5 is volume 4 of the trial transcript. Respondent 6 is the sentencing hearing transcript. Respondent 7 is the motion for new trial hearing transcript. Respondents 8 is the appellant's brief. Respondents 9 is the appellee's brief. And Respondents 10 is the unpublished decision of the Court of Appeals on direct appeal, and we tender those at this time.
Mr. Zell, do you have any objection to any of those?
No, Your Honor, I do not.
They're received.
And we have nothing further at this time, Your Honor.
All right. Mr. Zell?
Judge, if I could just have 1 second, there may be one document I want to tender from the Cobb's clerk's office. If I can just have 1 second to look at that. My notes real quick.
While you're looking, Mr. Zell, the null pros order is part of Respondents 1.
Oh, I'm aware of that. Yes, I would like to tender. I haven't marked it yet, but it is Cobb County indictment number 103045. I'm going to screen share it here. This case was re-indicted. This is the original indictment. And I think it's relevant for purposes of the arguments regarding the armed robbery, the two issues of the armed robbery. And I'm going to share this here. Let's see. And then I'll mark it. Well, I guess I'll go ahead and, I'll mark it. I'll just identify as petitioners 1.
I have no objection.
Oh, okay.
Whatever it's worth.
And it's received. Just for my information, though, this is not the indictment he was tried under?
No, Your Honor, this is this case was the original indictment, and it was re-indicted.
Yeah, I just wanted to make sure I understood that. But Ms. Smith has no objection, that's fine.
Okay, so I'm going to tender this as Petitioner's Exhibit 1 then.
Will be received.
And with that, then the petitioner would rest.
All right.
I'm just,
And we have nothing further, Your Honor. The rest as well.
Okay. Thank you, folks. Ready to go to your next one, Mr. Zell?
I need to see if, let's see if Mr. Garner's there. Do you have another one that could go and I could kind of?
I'm here. Can you hear me?
Yes, I can hear. Is that Mr. Garner?
Yes.
We could do the other case. Miss McCandless is going to handle that.
That's fine. Give Mr. Zell a break?
That would give me just a few minutes for a break, if that's all right.
Yeah, that's fine.
Okay, thank you.
Which case is it?
I think it's Baker, Judge.
It is number 9, Your Honor, the Bell case.
Bell?
Bell, he's challenging a guilty plea, and we have his former plea counsel as a witness. Bell. Item 9.
Roderick Bell. Is Mr. Bell here? No.
We need Roderick Bell, Smith State Prison. Mr. Bell, is that you, Raymond Bell?
Yes, sir.
Okay.
Can you hear us, Mr. Bell?
Yes, sir.
All right. You ready to proceed in your case?
No, sir.
Yes, sir.
You asking me,
What is your problem, Mr. Bell?
Now, I was, just been going through some things with, obtaining a lawyer. I had one, and, he just seemed to just not show up for last court, the last hearing we had. So, on the basis of one of the witnesses didn't come from Cobb County last time, they had asked for a continuance, but I figured I've been and got in contact with my lawyer, but I haven't heard from my parents, or he hasn't returned no calls or anything. So, I mean,
Mr. Bell, I don't see anything in the file indicating that the lawyer has made any entry of appearance on your behalf.
yeah, understandable. That I was trying to get some clarity, trying to go into the law library, you know, just get some kind of recognition of what direction I'm trying to go in with my habeas, but you know, we ain't been going to the law library, you know, it's a lot of stuff that's just been hindering me from doing my research on my case or the habeas and everything. So, I mean, I'm still at the same time trying to get a lawyer to represent me. I ain't just been some hardship. I just ain't been able to stay consistent in going to the law library, sir.
Yes, sir. Well, I understand that, but the state is here and is ready, and the case is on the calendar. I'm going to order the case to go to trial. If there are things that you feel need to be added to it, I'll leave it open for 30 days so that you can add to the record, okay?
Yes, sir.
All right.
Well,
That's about as fair as I can be to you right now, I think. All right, who's handling this, Ms. Smith?
Kathleen McCandless, Your Honor, McCanless.
All right. Mr. Bell, I want you to listen because I'm going to ask this young lady to give me the status of the case as we sit here this morning. Would you tell us where we are right now? And Mr. Bell, listen carefully because I'll give you an opportunity to respond once this is done, okay?
yes, sir.
She's muted.
Your Honor. Petitioner is currently challenging his August 2016 Cobb County convictions, which arise from a guilty plea for rape, kidnapping, and aggravated assault. He has raised 2 claims with round 1. He alleges that his plea was not knowing and voluntary, claiming that his guilty plea counsel was ineffective in investigating his case and advising petitioner. And in ground 2, he alleges he received ineffective assistance of guilty plea counsel, claiming that counsel made significant errors that fell below reasonable professional standards in investigating petitioner's case and advising petitioner. And the second setting of the case. And we have a witness today, petitioner's former guilty plea counsel, Mr. Fudger.
All right. Mr. Bell, do you agree that that's the status of the case, that you have raised ineffective assistance of counsel in 2 aspects, essentially saying that your plea was not knowingly and willingly made, and that counsel was ineffective in not properly investigating your case, his representation of you fell below the legal standard? Would that be a fair statement of where the case stands?
Yes, sir.
All right. I'm going to let them call their witness. You need to listen carefully, Mr. Bell, because I will allow you to ask questions of this witness at the conclusion of his testimony. Bear in mind that they have to be questions. You can't argue with him, but I'll allow you to ask any relevant questions that you think are appropriate after he testifies, okay?
Yes, sir.
All right, Colin, who's your witness?
Respondent calls Arthur Lee Fudger.
Mr. Fletcher?
That's me, Judge.
There you go. I see you now. Raise your right hand for me, please. The evidence you'll give is or affirmed to be the truth, so help you God.
I do.
Thank you. You can go ahead.
Could you please state your name and spell it for the record?
Arthur Lee Fudger, ArthurLeeFudger.
And what year were you admitted to the Georgia bar?
2007, 6? Either 6 or 7, I'm not sure.
And what do you currently do?
I'm a private practitioner practicing primarily in criminal defense.
And could you give a brief description of your job history?
As soon as I graduated law school, I became a staff attorney for the senior judges in Cobb County. Practiced for about 2 years there. Then went to the Fulton County District Attorney's Office for a little bit under a year. Left there and became the staff attorney to Judge Kenneth Nix. And upon his retirement, Judge Reuben Green was appointed to his position. I stayed on for a little bit under 2 years until I could get a replacement into my place under Judge Reuben Green. And then I went into private practice and have been in private practice ever since, primarily doing criminal defense.
And would you say the majority of your practice has been criminal law?
Yes.
How many felony jury trials had you handled at the time of petitioner's plea?
Uh, 2000, I don't, probably 10 to 15 at the time, felonies.
And about how many felony guilty pleas had you done at the time of petitioner's plea?
Probably 100 to 200.
And how did you come to be on petitioner's case?
If I recall correctly, and just reviewing my notes, the petitioner had hired private counsel, Thomas Robinson, and the case was set for trial of August 4th of 2016. I do a lot of appointed work in Cobb County, and there was some issue with the hired counsel medically. He just, I guess, insisted that he could not go forward with the trial that day. And I just happened to be in the courthouse. I don't remember if it was the circuit defender's office or if it was Judge Green's office that called me. But somebody said, can you report, somebody, the hired counsel cannot go forward, and this person needs counsel. I reported, and Judge Green instructed me that the case was set for trial, that private counsel couldn't go forward, and that he wanted to appoint me to represent Mr. Bell. And I think he's, at that time, special set us for trial like the 16th or something of that month.
And how did you prepare for petitioner's case?
That day, I spoke with Mr. Robinson. He turned over the file, and I spoke with Mr. Bell. We went over, just reviewed the file, the state's filings, and possible consequences of going to trial and things like that. So, like I said, the state's filings and mostly Mr. Robinson's file itself. I think he handed me a paper, his whole physical file that contained the state's discovery and all of his research.
Okay. And turning to petitioner's allegations in this case, was that all of the investigation you had done that you just previously discussed?
Yes, I think Mr. Robinson had done a pretty good job investigating the case, and it answered most of my questions. And I spoke with Mr. Bell and went over everything with him. I didn't have any unanswered questions about the case or the facts or the discovery.
And did you ever pressure petitioner into pleading guilty?
No. I make it a point. It's not my decision. And I make it a point to let them know it's not my decision. It's their decision of what they want to do.
And when petitioner pled, were you satisfied that petitioner was entering his plea knowingly, intelligently, and voluntarily?
Yes.
And turning to his next allegation, he states that you didn't advise him. Did you advise petitioner of all of his constitutional rights?
Yes, I believe I did. I don't recall specifically, but I've done this many, many times, and I generally advise about everyone's constitutional rights.
And respondent has no further questions at the moment.
Mr. Bell, do you have any questions that you'd like to ask the witness?
You never just really gave a specific answer for Miss Kathleen McCandless. How long did you have time to prepare to represent me? She asked you how long you had time to prepare for.
I believe I was told in court that I would represent you on August 4th, 2016, and then we were set for trial, I believe, either August 15th or August 16th, 2016, so only a few weeks.
You mean tell me you knew about this here beforehand, and I didn't know about it till the day of the trial. You knew you was gonna represent me before the sixth, before I went to trial. You say you had time from the 4th of August, and trial started on the 16th of August. So you saying you knew already that you was gonna represent me? You didn't have no week. You came in the day,
Bell,
of trial.
Bell, I'll let you testify in a minute if you want to. Is your question, what exactly is your question?
I asked, he never gave a specific answer to Ms. McCandless.
Is your question, I'll try to frame it for you, you shut me up if I'm wrong. Is your question to the witness when he found out that he was going to represent you, the date? Is that what you want to know?
No, she asked him how long he had time to prepare to represent me. So
right.
now he's.
Let's answer that question then. To your recollection, how long did you have to prepare to represent him in trial?
To my recollection, as I recall, the judge or the circuit defender's office called me to come represent him in court that day.
And what day was that? Do you remember?
I don't recall if it was the plea date or if it was a date that I can't remember if it was the date Mr. Robinson couldn't go to trial and got sick, or if it was the date we did the plea.
Okay. Have other questions, Mr. Bell?
So I went to trial I began my trial the 16th of August. I found when my lawyer became sick on that first day, I seen him, remind you, I seen him that Sunday.
All right, Mr. Bell.
Sir.
I'm gonna let you tell me what you want to tell me, but do you have any other questions for this witness?
For the constitutional rights, and you telling me about I'm knowing me about my constitutional rights. That's what I've got a lawyer for. I don't even know what constitutional rights is, so I'm just, like I said, I mean, you saying you told me about my constitutional rights. I still to this day don't even know what the constitutional rights is. I'm all this is new to me, so even still though, you saying that it was no pressure or I wasn't driven into or coerced into taking this plea. Let me ask you, Mr. Forger, what was the plea originally from the DA? What was negotiating plea? I mean, what was what we negotiating besides the 25 years? Either the 25 years, take this 25 years, or go to trial and lose and take 2 + 5 years. If you don't go to trial right now, what she say? You're gonna go to trial. If you don't take this time right now, you're gonna go to trial and face 2 + 5 years in prison.
Are you asking what?
Did she not? Yeah, I'm asking. Did she not say? Did you not tell me?
Mr. Bell, wait a minute.
Yes, sir.
I'm confused. Are you asking what the plea?
Yes, sir.
Is that what you're asking?
Yes, sir. I'm asking him, Mr. Fudger, did the DA herself not say either take this 25 years or face 2 years + 5 in prison?
I don't recall plea negotiations, Judge, but I do remember, I don't have my file with me. Subsequent counsel contacted me and said that he represented Mr. Bell, and I turned the file over to them. But if I'm not mistaken, there was at least some 404B evidence and possibly recidivist issues that would have impacted sentencing after trial.
Okay.
Judge, I wasn't notified of any recidivist anything, sir. I wasn't told of anything from like I said, I had appointed counsel. on Monday, and he had 2 years to prepare for my trial. He never told me about my trial until 2 weeks going into the trial, prior to the trial. 2 weeks to he telling me I'm finna go to trial, and 2 weeks later I gotta prepare for a trial. But you had 2 years. I'm staying in the county jail for 2 years because you told me get some time under my belt and I can go home. So I fired Mr. Thomas Robinson because he didn't stand up to requirements. I asked him, so I told him to go get physical evidence from a establishment that would have exonerated me from even being in this position right here. I asked him to go to these establishments, get the camera footage, and that would have just killed everything. I told Mr. Robinson, sir, can you at least go get the camera footage and it'll be over with. You can just go and it's gonna show that everything was consensual, everything, the truck that you said in my warrant, I was not in no black vehicle, anything, sir. I just told him to do the research investigation. Yes, sir.
I'm gonna let you testify, but you're gonna have to be under oath when you testify. I'll let you verify that what you've already said is true. But do you have any
Yes,
other questions of this witness?
Nah, no, sir. I wish I did. I'm just not prepared, sir.
All right.
Just really not prepared right now. I know I got a lot of questions, but you know, I can't do nothing right now. But I just know this ain't right. I just know it ain't right, sir. So you know.
Do you have any other questions from the state?
Yes, Your Honor. Mr. Fudger, did you feel you did everything necessary to prepare for petitioner's case?
Within the bounds of my representation, yes. As I said, I was called in at the last minute. Of course, I would rather have, months on the case and to speak to my client a lot more, but it was my understanding that Judge Green had special set it for trial, and either we were going to trial or we were taking a plea. So I did the best I could in the time limit that I had.
And did you go over petitioner's waiver of rights form with the petitioner?
Yes.
And did he understand everything on that form?
He didn't ask me any questions about that. And I believe one of the questions is, do you understand the questions I just read you?
No further questions, Your Honor.
All right. Do you have any further questions based upon that redirect? Do you have any other questions?
Now, can I make a statement, sir?
I'm gonna let you make a statement in a minute, but if you have a question, now's the time to ask a question.
No, sir.
All right, thank you. All right, do you want to make a statement? You want to offer some testimony?
For me?
Yes, for you.
Now, I just wanted to say, like I say, sir, I didn't hire lawyers
Mr.
to
Bell,
represent you. Yes, sir.
if you want to testify, raise your right hand and you'll be subject to cross-examination by the state. Raise your right hand for me, okay? The evidence you'll give is sworn or affirmed to be the truth, so help you God.
Yes, sir.
All right, put your hand down. Now tell me what you want me to hear.
I'm not savvy with this court stuff, So if I hire a professional, someone that's professional to represent me, and you tell me that about, like Ms. McCann said about that, I have any notification about a waiver. Sir, I take this conviction and I come and I'm learning this as I go along what convictions is, or what waivers is. It's certain things that I had known at that moment that I probably ain't went to trial. I would have just you know, just went on ahead and tried what I had, you know, and, you know, it takes, by me taking a plea, it takes away from the opportunity, like I say, it just takes away a lot of weight, you know, the wavering of me just being able to exercise the truth, you know what I'm saying, try to, you know, get the truth a point across. So it's like, had I would have known these things, sir, I wouldn't just, you know, I wouldn't been able to just let it go like that. You know, I just feel like I just sold my soul to the devil. You know, I would have put up a better fight than this, and that's why I said, can y'all give me time to get another lawyer to represent me? You know, I mean, Mr. Thomas Robinson absolutely did nothing. Mr. Fudger absolutely did nothing to help me, you know, just get my point across. And what's the scary part is that Cobb County may have had evidence, or could have went to trying to get some evidence to help me to state the fact, the real truth of what really happened during this accusation. And, you know, it's a lot of other things that went along that is fresh on my mind, but it's, you know, it's kind of emotional, but it's just not you know, I just wish not to bring that to this courtroom right now. I'm just, you know, I just want to be straightforward and honest as possible, you know, because I raised my hand and I just know this situation is just blown out of proportion, and I just wish I was better prepared to, you know, just fight for my life, you know. So I don't know. Right now, I don't even know what stage we're in on this right now. I really just lost right now still, you know.
Yes, sir. All right. Do you have any questions you'd like to ask of him?
No, sir.
Do you have any questions you'd like to ask of Mr. Bell?
No, Your Honor.
All right. Do you have any documents to introduce or anything of that nature?
Yes, Your Honor.
All right. Go ahead, Mr. Bell. She wants to introduce some documents. You have an opportunity to object if you wish to. So listen carefully and see what she's going to introduce, okay?
Yes, sir.
Respondent's Exhibit 1 is the indictment.
All right. You have any objection to that, Mr. Bell?
No, sir.
All right, let's proceed.
Respondent's Exhibit 2 is the final disposition.
That is a final disposition. That's the sheet where it says what the judge gave you, essentially. Do you have any objection to that, Mr. Bell?
Sir, I see a life on the sentence. It says something about life, and I suppose it has a 25-year sentence. I don't know anything about a life.
It says life served 25 years.
See, that's what I'm saying. I ain't know nothing about it. What life? You know that life meaning.
Have a 25 years to serve sentence, as I read that under that.
Huh, sir?
Have 25 years to serve on count 1, if I'm reading that correctly. Then you have 20 years to serve concurrent. Then you have 20 years to serve concurrent.
Man, I just know it was supposed to be 25 years. That's it. I don't know nothing about no life. I don't understand that.
Well, I'm not sure really why it's there either, but the operative language is the 25 years to serve. So with Mr. Bell has a reservation, the court will receive that into evidence. What's your next one?
Respondent's Exhibit 3 is the null pros of the firearms possession charges.
All right, that's where they dismissed the firearms charges, Mr. Bell. You have any objection to that?
I never had a firearm. I
Well,
mean, I never had a firearm. I don't honestly.
okay, it was dismissed, so it doesn't have any bearing on your sentence. It's received. What's your next one?
Exhibits 4 is the waiver of rights form.
Mr. Bell, this is a waiver of rights form. It looks to be a pretty standard form. The word yes appears on most of the blanks there, indicating that they were read to you and you understood them. The word no appears on a couple of them. Under line 21, it says you are pleading guilty. It says also, number 22, you are in fact guilty. Number 23 says, have these questions been read to you and explained to you? The word yes appears there. And it says, on number 24, do you understand all the questions contained within this plea questionnaire? And the word yes appears beside in the blank beside question 24. The last part is advisement on your habeas rights. There's a signature line which appears to have your signature and the signature line that your lawyer certified, essentially that the defendant had been informed of the rights and had those rights explained to them. The last is a certificate signed by the judge. Any objection to that, Mr. Bell? I understand what you're saying, but these are documents which are in existence.
Yeah, I understand, but I mean, I didn't, like I said, I wasn't explaining about none of this stuff. I just, I don't know, man.
All right.
Like I say, if I'm taking a plea, I didn't know nothing about, after 30 days after I take a plea, that I could withdraw a plea. None of this, none of my stuff that was, supposed to have been telling me about, it never was brought to my attention until, afterwards. You know what I'm saying? Years or two passed.
All right.
So like I said, none of this stuff just, like I said, I don't know nothing about none of this stuff at the time. All I know is I'm just, that's why I hired a private attorney. I hired someone to do all this stuff,
Yes, sir.
And none of it was fulfilled. So it's like, I'm distraught. I'm frustrated. Like I say, even when Mr. Fudger, he didn't explain none of this stuff to me. I see my signature. I see my yeses and no's, but I don't know nothing about it. I didn't know that at the time. I didn't know nothing about this stuff.
All right. Mr. Bell has expressed some reservations about this. The court will receive it as evidence. What's your next one?
And respondent's final exhibit is respondent's 5, which is just a transcript of the guilty plea hearing.
Mr. Bell, this is a transcript of the guilty plea hearing. You have any objection to that?
You say, what is this, sir?
It's a transcript. It's where you stood in front of the judge. And the court reporter typed out what you said, what the judge said, what your defense counsel might have said. And this is the official transcript that is in the record. Where is it, in Cobb County? Is that right?
Yes, Your Honor.
This is the official record of that particular hearing that's in the clerk's file in Cobb County. You have any objection to that, Mr. Bell?
No, sir.
All right, that's received. Without any objection or litigation. All right, is that all?
Yes, Your Honor. Respondent has nothing else further.
All right. Mr. Bell, you have indicated 2 or 3 times that you have hired a lawyer. My recollection from the testimony of the lawyer who represented you was that he had turned over a file to the lawyer. That gives me some concern but there is absolutely nothing in your file to indicate that a lawyer has made an entry of appearance. So the court has ordered the case to go forward today. As I told you at the beginning, I will give you 30 days to supplement the record or make any motions that you might feel are appropriate. So if you feel as though you have hired a lawyer, you probably need to get in touch with whoever it is that you feel is your lawyer. Tell them what's happening. All right?
Yes, sir.
Thank you very
Your
much.
Honor,
Yes.
I just wanted to also mention that we discussed with Mark Yurachek, who I think originally petitioner was maybe planning to hire once we contacted him, and he said he was not going to represent petitioner.
Okay. Well, as I say, there's nothing in the file to indicate that anyone has taken on the petitioner's case. All right. Thank you very much, Mr. Bell. Here you go.
Oh, he's good.
All right, does that bring us back to Mr. Rizal? Thank
It
you,
does, Your
Diana.
Honor.
Ms. Smith, Paula, can I ask you a question?
Yes, sir.
I got a letter from Ronald Eaton, E-A-T-O-N, who apparently was one of the people I heard either down in Coffee County or Ware County. I don't think I've ever gotten a proposed order from you folks. And if you could check on that for me, I'd appreciate it.
Absolutely, Your Honor. Ronald Eaton.
E-A-T-O-N, yes.
Thank you, Your Honor. I will do so. Ms. Gillis had actually called while we started. She's got a list too, so they're in Coffee County. So we will get on it. I'm sorry.
I appreciate it. All right, are we waiting on Mr. Zell? While we're waiting on Mr. Zell, I'm gonna take a name on this road.
Oh, okay.
for that. All right, we ready?
Yes, we are, Judge. If Mr. Garner's ready.
All right, Mr. Garner?
Mr. Garner is talking to the DA. This is his assistant. He will be back in just a second. I'm gonna go grab him.
I thought I had stayed out long enough to.
Hello, this is Mike Garner.
Oh, okay.
Hello? All right, ready?
Mr. Garner, we can't see you, but if you can raise your right hand.
Okay,
And do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right. And would you state your name?
Michael Edward Garner.
And what is your occupation?
I'm an attorney,
And how long have you been an attorney in Georgia?
49 years.
And in those 49 years, what has been the primary area of your practice?
We only have criminal cases.
Okay. And at some point, did you represent Mr. Baker?
I did.
And what was that for? Did you represent for his trial?
Yes.
And do you remember how long ago the trial was?
No,
Okay. It was some time ago, is that correct?
it was many years ago.
Okay. Just 2008 sound correct?
That sounds right.
And were you appointed or retained?
Retained.
And do you recall reviewing the indictment?
Yes.
Do you remember the number of counts involved in the indictment?
No, there were several.
And did you obtain discovery from the state, from the DA's office?
Yes.
Did you review that discovery?
Yes.
Did you review it with Mr. Baker?
Yes, I talked to him.
And were there other defendants involved in this case?
Yes, I think there were a couple of brothers.
And when you say a couple of brothers, not Mr. Baker's brothers, but other defendants who were brothers between
There
themselves?
were two other defendants. There were two brothers who were the main parties in this criminal enterprise. And they had done a large number of home invasions. And Mr. Baker had just met them and was kind of on the periphery of this whole thing.
Okay. Did this indictment involve, I guess, multiple different incident dates?
I don't remember.
Do you recall if Mr. Baker was charged in all of the accounts of the indictment?
I don't remember.
Okay.
And the reason is there were a number of trials with a number of different defendants.
And was Mr. Baker's trial, was he the only defendant on the trial for his trial, or were there other defendants?
If this was the robbery at the Piggly Wiggly, I think he may have been the only one.
Did you develop any kind of defense strategy, as you recall?
I don't remember much detail about the case.
Okay.
I remember the two brothers, and they testified against him, and one of them made a deal with the state to be a witness, and he testified, and our defense was that the defendants who had made a deal with the state were not telling the truth.
Okay. That's what you would call as a primary, or at least one of your primary defenses?
Yes.
Now, I'm going to go into some of these two specific issues. Do you remember there being any evidence of any similar transactions admitted against Mr. Baker?
I don't remember.
Okay. Did you have the opportunity to go to review the transcript or the issues that I sent you?
I didn't get any issues. I looked for them, but I didn't receive them.
You didn't receive it, the transcript of the, okay.
I've got the transcripts, but there's nothing about what to look for, what you were interested in. The only thing I got was a case, Supreme Court case about that dealt with whether the judge unduly restricted my cross-examination.
Okay. All right. Now, going back, do you recall any issues about similar transactions in the case?
I don't recall that.
Okay. And I cannot show you the transcript to see if it refreshes your memory either. I'm not sure. Do you have did you have it, the transcript available to you right now?
No. I'm in the courthouse in Americus, Georgia. And we have a hearing starting at 12 o'clock here. My office is in Columbus. And I'm sitting here on my iPad outside the courtroom handling this hearing.
Okay.
I don't have any files, or my computer's not here. I don't have anything but my iPad. Ordinarily, I'd have all that available, but I'm traveling.
You know, Judge, I guess under these situations, I would ask the case be continued. There's really no way to proceed with Mr. Garner just on the phone, not being able to look at the transcripts.
Well, I agree with that because it's been so long, and there are two trials we had involving Mr. Baker, and they run together. I really couldn't separate them in my mind unless I know what we're talking about and have a chance to look at the transcripts. We've got about 700-800 pages of transcript between the two trials. There were a lot of issues raised.
Any objection?
We don't object to putting the case over, Judge. It's obvious Mr. Garner's out of pocket and
Yeah. I don't see that we can do much of anything else. All right.
Okay. All right, thank you, Judge. That concludes my business. May I be excused?
Yes, sir. Thank you.
Thank you, Your Honor.
Judge, is that it for Smith State Prison?
Can you close it up?
Are you done?
Yeah.
You want me to leave it? Leave the chat?
Are we done? Is that I'm looking at? Are you Mr. Baker?
Yes, sir.
Mr. Baker, your case has been continued at the request of your lawyer. Do I need to go with the calendar? Do you have anything else?
Who do we have at Georgia State Prison? If you would unmute yourself.
Right now we have
Vincent.
Vincent Harris.
You want to do Harris? Do you want to do Harris, Miss Smith? Oh, you're muted.
Yes, we can do Harris. Ms. McCandless is going to handle that. We have limited readies for both it and the Omari Smith case, which are the only two I think still left on the calendar.
Okay.
Ms. Smith.
Yes.
I'm supposed to George Rose.
Could you tell me about Martavius Henry? You don't need him?
About who now?
Martavius Henry.
A motion to continue was filed. Continue his hearing to the next hearing date.
Yes.
By his.
Okay, thank you.
That's right, I read it.
So they just switched judges on me.
No, that's Judge Rose on there.
Okay.
All right, who is it we have here now?
Your Honor, we have Vince Harris from Georgia State Prison.
That's there, gotcha, thank you. How are you,
You're welcome, sir.
how are you today, Mr. Harris?
Yes, good morning.
Can't hear it.
I'm doing all right, sir. How are you doing?
Oh, I'm all right. You ready to proceed?
Yes, sir. I just want to make sure I can hear you because I don't hear that well.
Well, I don't hear that well either. If you have a problem hearing me or anyone else, let me know, okay? And we'll try to speak a little louder and a little clearer.
All right, sir.
All right. I'm going to ask the state to give me an update and an overview of where this case stands today. I want you to listen carefully because I'll give you a chance to respond after she tells me the status of the case, all right?
All right, sir.
All right, listen up. Okay.
You're muted, Ms. McCandless.
How you doing?
Can you hear me now?
We can hear you now.
Yes, ma'am.
Okay. In this case, petitioner is challenging his November 2016 Muskogee County jury trial convictions for 2 counts of malice murder, which petitioner received consecutive sentences of life without parole. He appealed the convictions in Harris versus State, and the Supreme Court affirmed both convictions. And today we're announcing a limited ready, assuming that petitioner does not raise new claims that would require additional exhibits or witness testimony.
All right.
Well, ma'am, on that, I do have the crime scene photos, and I do have the transcripts from the arraignment, which are very important that I would like to show.
Well, I imagine there will be no objection, at least to the transcripts. We'll get into it and see, okay?
Also, sir, I had sent you a copy of the autopsy reports and showing the reconstruction of the crime, showing how it actually went down.
All right, do you want to offer some testimony? I've got your file here. Do you want to offer some testimony today?
Yes, sir, I do. What I would like to do, sir, is open with an opening statement.
All right.
And once I finish my opening statement, we'll go from that.
What is your opening statement then?
All right, sir. On 24 February 2012, lead homicide detective Matt Blockstock needed a police ID tech to join his team in double murder. Detective Matt Blackstock called on Detective David Jury to join his team at the crime scene of the home of 47-year-old black female Tina Greenhall and her 6-year-old black male child, Jeremy Hall. Both found dead in that home, lying in Jeremy's bed in his bedroom. Both had a single gunshot wound, entrance hole in their upper left chest. Tina had an exit wound hole, while Jeremy's exit wound hole, Tina had no exit wound hole, while Jeremy's exit wound hole was found in his right side, meaning that Jeremy was shot at an odd angle of left to right and downward. A closer look at Tina's wound hole was also at an odd angle of left to right and downward. No exit wound hole. So say expert Dr. Posey, Dr. Jordan, Detective Jury. Dr. Posey also stated that Tina's wound hole was oval. The muzzle was at an odd angle to make an oval wound hole. Detective David Jury's task that day on 24 February 2012 as the ID tech was to be a part of Detective Blackstock's homicide team to make photos, look at any fingerprint, glove print marks, crime scene reconstruction, bullet trajectory, trace the bullet back to the muzzle, the angle of impact, and to, but not limited himself to only those things, plus muzzle to target distance, telling where the shooter or shooters may have been standing the moment the shots were fired. We know that based on crime scene photos, that Detective Jury placed his trajectory rod through the plastic and through the box spring, showing the angle of that shot as it exited Jeremy's body through his right side. No mattress on that bed, just a box spring with a fitted sheet on it. We know that Detective Jury, based on photos of the crime scene, found no bullet holes in those sheets on Jeremy's bed on 24 February 2012. We know that Detective Jury took photos of Tina's gun box, showing rubber glove marks that Detective Jury found at Tina's house on 24 February 2012. And somehow, not one homicide detective, to include lead homicide detective Blackstock, knew about those glove marks that Detective Jury claims he found on that gun box. We also know that those photos of those glove marks could not possibly have been printed out at Tina's house. But that does not take away the fact that Detective Jury failed to tell anyone what he found on that gun box that day. We know that Dr. Douglas Posey performed the autopsy on Tina and Jeremy on 25 February 2012. We know that by state law, the manner of death on Tina and Jeremy must come from law enforcement. In this case, Detective Blackstock and his whole team agreed it was murder-suicide. So Dr. Posey closed his autopsy report out on June 2012. After many days of talking with Detective Blackstock, Dr. Posey placed on his autopsy report murder-suicide of Jeremy and Tina Hall. We know that Detective Blackstock and his whole team, to include Detective Jury, all agreed that it was a murder-suicide, and that Detective Matt Blackstock closed out their investigation in August 2012. We know that 6 months after Tina and Jeremy were found dead, Detective Jury still had not told Detective Blackstock or Dr. Posey about any glove marks that he claimed he found and photoed at Tina's house on 24 February 2012. We know that those two homicide detectives who interrogated me on 24 February 2012 for over 7 hours never asked me or told me anything about glove marks found by Detective Jury on Tina's gun box that day. And I was never questioned by any law enforcement again until my arrest by Detective Randy Long on 22 December 2014. And even then, there was no talk about any glove marks to me from Detective Randy Long. If detective jury found glove marks on a gun box at Tina's house on 24 February 2012, why did he not tell those homicide detectives or cold case detective Randy Long? Sometime in January 2013, detective jury met with cold case detective Randy Long. Detective jury did not tell Detective Long anything about glove marks or photos of glove marks taken at Tina's house on 24 February 2012. Detective jury and Detective Long only talked about bed sheets and crime scene photos of the bed that Tina and Jeremy were found dead in. We know that after detective jury talked to Detective Long, detective jury went to the evidence room, got those sheets, and took photos of those sheets showing what he now believes are bullet holes in the top sheet and the bottom fitted sheet, January 2013, that detective jury could not find in February 2012. We know that Detective Long in January 2013 went to see Dr. Posey with those holes in those bed sheets and crime scene photos, but no glove marks. Detective Long asked Dr. Posey, based on this new evidence, that Tina was murdered first and then her son was shot, based on the movement and displacement of those bed sheets, to change Tina's autopsy report to murder. We know that Dr. Posey knew the state law and that he clearly understood the state law in this matter. Any evidence given by law enforcement cannot and will not be questioned by any coroner in the state of Georgia. Yet Dr. Posey did in fact question that new evidence shown to him by Detective Long. And Dr. Posey refused to change Tina's manner of death to murder per request of Detective Long. At that point, Dr. Posey broke state law, and for good reason. Tina was not murdered, and Dr. Posey knew that, and changed the manner of death to undetermined only. We know that Detective Long's request on the gunshot residue report on Tina's hands came back on 11 March 2013, showing more than 5 particles of gunshot residue on her hands, which is the most that the GBI looked for and stopped counting it. Report done by Dr. Christine Dedrick, and it had Detective Long's name on it. We know that Detective Long waited for Dr. Posey to retire, and in December 2014, Detective Long went to see Chief ME Dr. Chris Sperry with the same evidence that Detective Long showed Dr. Posey in January 2013. Right there. Did you hear that? My rights to a fair trial and probable cause was taken from me by Detective Randy Long. Nearly 2 years had passed, and Detective Long had the exact evidence for both Dr. Posey and Dr. Sperry. Why, after nearly 2 years of additional investigation, did Detective Long have no new evidence to show Dr. Sperry? We know that the gunshot residue report on Tina's hands came out on 11 March 2013, requested by Detective Long and submitted by Detective Long, and it came back to Detective Long. We know that Detective Randy Long did not show that gunshot residue report to Dr. Sperry. We know that I was denied my rights guaranteed by the amendments of the United States Constitution, that Detective Long, with reckless disregard for the truth, withheld Tina's gunshot residue report of more than 5 particles of gunshot residue on Tina's hands from Dr. Sperry. And likewise, Detective Randy Long and State's Attorney George Lipscomb also withheld that gunshot residue report on Tina's hands from the judge to get my arrest warrant, the judge at my arraignment, the judge at my bond hearing, and the grand jury to get my indictment. They took away my due process of equal protection. We know by state law that Dr. Sperry changed Tina's manner of death to reflect murder based on bed sheets and crime scene photos and the opinion of Detective Long. However, we know that Detective Long did not disclose the fact to Dr. Sperry about Tina's gunshot residue report dated 11 March 2013. We know that Detective Long took that autopsy report that stated murder of Tina to the state's attorney, George Lipscomb. And in December 2014, Lipscomb took the autopsy report to a judge and got an arrest warrant on Vince Harris. We also know that the state's attorney, George Lipscomb, failed to disclose the fact that he was given that gunshot residue report on Tina's hands on 11 March 2013 before getting that arrest warrant. That showed more than 5 particles of gunshot residue on Tina's hands. We know that is malicious and malice prosecution on the part of the state's attorney's office, and it took away my rights of probable cause. We know that Detective Long and State's Attorney Lipscomb told the judge in Recorder's Court, my arraignment, that I had gunshot residue on my clothes, and the judge never asked about gunshot residue on my hands. So the glove marks never came out of Detective Long's or State's Attorney Lipscomb's mouth. We also know that without being asked, that Vince told the judge that they did a gunshot residue test on my hands, and no gunshot residue was on my hands. Detective Long and State's Attorney Lipscomb had no comment, which also proves that detective jury kept those glove marks hidden from Detective Long when they spoke in January 2013 about bed sheets, and detective jury never went to the DA's office about glove marks. He said they're originally found on 24 February 2012 at Tina's house. So why is detective jury keeping those gloves hidden from other law enforcement members? Also, we know that the state's attorney Lipscomb in December 2014 at my arraignment told the judge they saw no physical evidence of gunshot residue on Tina's hands. Once again, the state's attorney showed a fabrication of the evidence and malicious malice prosecution and took away my right to probable cause. My case was bonded over to Superior Court without bond, which violated my constitutional rights of probable cause. We know that I hired an attorney, Stacey Jackson, in January 2015. He was present at all of my bond hearings. At every bond hearing, all 4 of them, the judge asked State's Attorney Lipscomb what evidence he had and when was he going to get the grand jury to indict Vince. We also know that the state's attorney, George Lipscomb, had no real reply. And state's attorney did not talk about glove marks or the fact that he had evidence that Tina had 5 particles of gunshot residue on her hands to Judge Mullins, my bond hearing judge. We know the first bond hearing under Judge Mullins was set at no bond for 2 counts of murder. My second bond hearing was set at $170,000, 2 counts of murder. My third bond hearing was set at $120,000, 2 counts of murder. My fourth and final bond hearing was set at $60,000, 2 counts of murder. So I bonded out in October 2015. My bond paperwork stated that I could not and would not leave Columbus, Muscogee County, Georgia for any reason. We know that the grand jury indictment came down in April 2016 and that the state's attorney's office failed to tell the grand jury about the gunshot residue report on Tina's hands, or those glove marks found by detective jury 24 February 2012. We know that an indictment by a grand jury creates a presumption of probable cause that may be only with evidence that the indictment was the product of fraud, pressure, suppression of evidence by police or other conduct taken in bad faith. We know that Detective Long and State's Attorney Lipscomb both knew about gunshot residue report that came out on 11 March 2013 on Tina Greenhall's hands, and they withheld that information from the grand jury. The judge at my bond hearing, the judge at my arraignment, the judge that issued my arrest warrant, and Dr. Sperry, who amended Tina's autopsy report to reflect murder. None of them were ever told about gunshot residue on Tina's hands. We know that on 3 June 2016, after my indictment on 2 counts of murder, that I paid my attorney, Stacey Jackson, $500 to get me new bond paper, letting me move out of Columbus, Muskogee County, and live with my son in Atlanta. That new bond paperwork was signed by Judge Mullins, State's Attorney George Lipscomb, and my attorney, Stacey Jackson, who told me that too many counties to confine me to 1 county so I could go anywhere I wanted to go. I'm from North Carolina, so I went
Excuse
there
me,
and came
Your
back.
Honor.
All right.
It appears petitioner has been going more into arguments rather than an opening statement. We'd like to note that. And
He is, I agree 100%.
Okay, so ma'am, I'll admit that. We now know that State's Attorney's Office had no proper cause to institute the action that the absence of proper cause is an essential element of malicious prosecution. There was no proper cause for the criminal charge on which I was prosecuted. And the fact that Detective Randy Long withheld the gunshot res report on Tina's hands from Dr. Sperry, and the State's Attorney's Office also withheld that same information with getting my arrest warrant, getting me bonded over to Superior Court, getting a grand jury to indict me, shows malicious prosecution that my attorney, Stacey Jackson, should have presented to my trial judge at the start of my trial, 7 November 2016. How is it possible that Detective David Jury kept those glove marks evidence hidden from 2012 until my trial, November 2016? How is it also possible that Detective Randy Long and State's Attorney George Lipscomb kept that gunshot res report on Tina's hands of more than 5 particles of gunshot residue hidden from March 2013 until my trial, November 2016? And what Dr. Sperry did was what the state ordered him to do: obey law enforcement by faith as he changed Tina's manner of death to murder. The state law is wrong, and innocent people do go to prison because of that state law. And Dr. Posey understood and disobeyed state law. And Detective Randy Long showed bad faith by not disclosing the gunshot res report on Tina's hands to Dr. Sperry, just to get an autopsy report that stated murder of Tina Greenhall from Dr. Sperry. What are your questions, ma'am?
Now, you have given us an opening and a closing, and you've offered some testimony. So I'm going to ask you to raise your right hand since you have offered some testimony and swear that what you have said in terms of factual evidence that you want the court to take is true. Raise your right hand for me. The evidence you have given is sworn or affirmed to be the truth, so help you God.
So help me God, it's the truth.
All right, thank you very much.
One question I'd like to ask you, sir. I can prove it with the transcripts from the arraignment. In the arraignment, they told the judge point blank that they saw no physical signs, no visible evidence that Tina Greenhall had gunshot residue on her hands. And they knew that was a lie because the report came out on 11 March 2013. I went to the arraignment on around 27 December 2014. So how is it possible they did not know? And even when I told them I had no gunshot residue on my hands, they had no comment. They told the judge they found gunshot residue on my on my clothes, which was all. They found gunshot residue on my pants, 2 particles in the crotch of my pants. And I got the gunshot residue reports to prove it. They fabricated evidence, they lied in court, and they took away my constitutional rights. And now I'm in prison.
What specific evidence do you say they fabricated?
Say again, sir?
What specific evidence do you say they fabricated?
They fabricated evidence that they said Hall had no gunshot residue on her hands. That's the evidence they fabricated.
All right, is there anything else?
Other than if you have questions, I can answer your questions. The thing about the glove marks, like I said, they didn't show up until we went to trial. Then once we went to trial, detective jury started talking about, oh, we found glove evidence. Okay, why in 2012 would detective jury, he's at the crime scene. He's part of the homicide detectives.
Yeah,
Dr.
you've gone over that. I understand your point. Do you have
Okay. How is it possible that in 2012, this detective says she committed suicide, and then in 2014, he says, oh, it's murder based on bed sheets?
That's about the third time you said that. I understand what you're saying.
Okay, sir.
Does the state have any questions?
The state would just like to note that the Supreme Court has already ruled that the evidence was sufficient, and otherwise, respondent has no questions.
All right.
That evidence didn't come out of the Supreme Court.
All right.
And I've got paper, excuse me, sir, don't mean to cut you off, but the same information I sent to the judge, I also sent the information to the Supreme Court because I want to know what the Supreme Court would say. And you know, they gave me something that was, how would you say, amazing, what they told me. They pretty much said, my attorney came to them and didn't bring them the right information. He tried to go out the hearsay evidence. Hearsay evidence had nothing to do with this case. Hearsay is what he went after. He didn't go after what I just explained to you, and I tried to get my attorney to do that. But like most people, they don't want to believe that people in position of authority will lie. I don't know why. They lie like everybody else.
All right. Does the state have any documentary evidence?
Yes, Your Honor.
All right, Mr. Harris, look closely because the state is going to introduce some documents. If you have any objection, let me know.
I have no objection about the document she introduces.
Okay. Tell us what they are then.
Oh,
she's okay, here we go.
Respondent's Exhibit 1 is a copy of the record.
All right.
Respondent's Exhibit 2A is the first volume of the jury trial.
Okay.
Respondent's Exhibit 2B is Volume 2 of the jury trial.
All right.
Respondent's Exhibit 2C is Volume 3 of the jury trial.
Okay.
Respondent's Exhibit 2D is the next volume.
It says 3.5.
3.5. Yeah.
That's okay.
And here's Volume 4, which is, excuse me, Your Honor, looks like that's also Exhibit 2.
Okay. 3.5 and 4 combined, then that's fine.
Respondent's Exhibit 2E is Volume 5 of the jury trial. And Respondent's Exhibit 3 is the exhibits from the jury trial.
All right.
Respondent's Exhibit 4 is a transcript of the motion for new trial.
Okay.
Respondent's Exhibit 5 is appellant's brief.
All right.
Respondent's Exhibit 6 is the brief of the DA, the appellee.
Okay.
Respondents Exhibit 7 is the AG's appellee brief.
All right.
And Respondents Exhibit 8 is the reply brief.
Okay.
And Respondents Exhibit 9 is the motion for reconsideration.
Okay.
And that is our final exhibit, Your Honor.
Okay,
All right.
ma'am.
Mr. Harris, you have
Yes, sir.
indicated you have no objection to any of those exhibits. Is that correct?
By objection, I mean I don't have no problem with showing them. I do have an objection based on the fact that my attorney only went after hearsay evidence on all of those forms. As you saw, he talked about Charlene Dolman. He talked about Patricia Sherrod. He talked about statements that people said I would kill somebody, which was more than hearsay evidence. He never asked me, was any of that true? So I don't have no problem with us showing those things, but I do object to the fact that my attorney failed to go after the true evidence, which was the gunshot residue on Tina's hands. And ma'am, with all due respect to you, I understand you got a job, but you are trying to keep a person in prison based on not the truth. The truth is,
I understand your concern. You have not voiced an objection. So those are received. Mr. Harris, do you have any documents that you want to introduce into the record?
yes, sir. I got the transcripts from Recorder's Court, which shows clearly that the state's attorney, along with that detective, fabricated evidence to my arraignment judge to get me bonded over. And that is a problem.
Have you shown them to the Attorney General's office? Have you supplied them with copies?
No, sir, I did not. What I supplied them a copy of was I sent to them the autopsy reports. And if I also, sir, sent you a copy of the autopsy reports. And the autopsy reports, yes, sir.
I've got it. I just looked at it. It's in the file.
Okay. The autopsy report right here that I sent to you.
There's
two of them.
I just looked at both of them. They're in the file.
Okay, sir. Here's the problem with these two autopsy reports. Both autopsy reports were done by Dr. Posey. Both these autopsy reports are word for word from Dr. Posey. So when Dr. Spurry, all he did was, like most of us do, get lazy, go online, go to page 5, and change the paperwork on page 5. That's all Dr. Posey did. He did not change any of the, what you would call the initial report. And he even said so. Everything that Dr. Posey wrote, he said was good to go. He had no problem with it. Only problem he had was with when he changed it from suicide to homicide based on information from the Columbus Police Department.
Right.
Okay, so here's the problem with that, sir. Dr. Posey said that Tina was...
Mr. Harris.
Yes, sir.
Is this a new problem, or is this a problem that you've already expressed?
It's a new problem because it's about how long it took her to die. The state's attorney suggested...
I'll let you tell me that then, if it's new.
Okay, it's new, sir.
What is it?
Okay, sir. They based their facts on it took Tina Greenhall died instantly. Dr. Spurry agreed with that. Dr. Posey did not agree with that. Okay, so let's talk about what Dr. Spurry said he agreed to. He agreed that, which he did not even read. He said he read it, but he didn't. How can you agree with over a gunshot wound? You can't even explain to me how she got an over gunshot wound in her upper left chest of her breast. You can't make the shot. And I'll pull out a diagram. I'll show it, if you don't mind, sir.
Is this the same diagram that you sent here?
Yes, sir.
All right.
Same diagram.
I've seen it. I saw it in the file.
All right, sir, it's in the file. and it shows you where a gunshot wound is at. Upper
Yes.
left breast of the chest. Make the shot. Somebody make the shot. If you can't make the shot, then it's a suicide. Because no one can make that shot but the person that did it, and that person is dead. So you're fabricating evidence. You're blaming me. They didn't even talk about the over gunshot wound hole. My attorney didn't even mention it. Dr. Posey mentioned it, and my attorney quickly tap danced over it. But he did do one thing that everybody should understood. He told him about the blood loss. He tried to explain as best he could that her gunshot wound in itself was not life-threatening. As soon as he said it's not life-threatening, that takes away your...
Objection, Your Honor. He's been going into hearsay.
Well, I agree with that.
That's not hearsay, ma'am. I got it on there. I got it in court transcripts where he tried to explain it. And my attorney kind of pushed it to the side. And you know the state's attorney...
Are the court transcripts a part of the record? They are. Is that right?
Say again, sir?
The court transcripts are a part of the record.
Yes, sir. But she didn't show the court transcripts. All she showed was little bits and pieces. Ask her to show the court transcripts.
They're a part of the record. That's what they were. Do you have any documents? Now, you said something about a preliminary hearing or a magistrate hearing?
Yes, sir. I talked about recorder's court.
Do you want to introduce that transcript?
Yes, sir. I would love to use that transcript.
Then you need to send it to the clerk.
Right here.
You need to send it to the clerk, send a copy to the Attorney General's office, and I'll give them a chance to object or okay. All right? That'll be made a part of the record.
Okay, let me get this clear, sir. I need to send a copy to the judge.
To the clerk, well, yeah, to the judge.
And also to the Attorney General.
Yes.
Along with that, sir, I would like to ask you, would I be able to also send those gunshot residue reports that came out showing the fabrication of those attorneys?
You send whatever you think you want to introduce into evidence to the clerk or the judge. And also,
I got you on that.
And also,
that's a done deal.
And also send the copy to the Attorney General's office. Case will be held open for 30 days to allow you to do that.
As soon as, here's the problem with that, sir. I understand you have a time limit, but I'm in prison. I have to depend on the law library to get this paper, make copies of it, get it back to me, then send it up. So that might be the problem.
Well,
excuse me for a moment, sir. Ma'am, here it is. This is from the, which y'all call the arraignment. We call it recorder's court. And in recorder's court, I can show you, if you don't mind me showing you, ma'am.
I actually can't see the text. It's too
If
far.
I get closer? All right, ma'am. Let me get closer. Can you see the text, ma'am?
No, it's still too small.
It's small. We can't read it. All right?
Okay. But the bottom line is this, ma'am. They stood in the arraignment court, and what I got circled right there, and you can see the ink marks, they told that judge in the recorder's court, the arraignment, that they saw no physical sign, no physical evidence that she had gunshot residue on her hands. I had no gunshot residue on my hands. None.
You had some on your pants. We've heard that. Go back and sit down.
In the crotch. In the crotch, sir.
Go back and sit down. I remember. All right.
As quickly as I can get them to make me my copies, ma'am.
Get it to them, okay?
Who do I address this to? You, ma'am?
Yes.
All right. If you don't mind.
With all due respect, send it to the attorney whose name is on the answer, Michael Oldham. This is his case. Ms. McCandless is just handling the hearing today. You have Michael Oldham's name and address on the answer he filed in this case. That's where you should send it. If you excuse me, Judge, for jumping in.
No, I was just going to say send it to the Attorney General's office. So, you know.
I got the address on it, says 40 Keppel Square, Southwest Atlanta, Georgia, 30344, 1300.
You've got the address, all right. Get that done and the case will be over as far as the hearing goes. Unless the state has anything, you announced a limited ready. So do you have anything else that needs to be addressed?
It doesn't look like it, Your Honor. I was wondering, are we going to have the chance after viewing these to object if we want to?
Yes, that's why I'm asking him to send them to you.
Okay, I'm sorry, Your Honor. I just wanted to clarify.
Well, I'm not very clear.
Okay, ma'am.
All right.
So this form right here showing Tina's green home, gunshot wound home.
Mr. Harris,
Yes, sir.
send the form. Give them an opportunity to object. And if no objection is made, it'll be made a part of the record. If an objection is made and it's overruled, it'll be made a part of the record. All right?
Okay, sir. What I want to make clear is now, on my paperwork, I got Christopher Carr, Beth Burton, Paula Smith, and Michael A. Odom. That's the only addresses I got. So which one of these do I send it to?
Michael Oldham.
Michael Oldham.
Assistant Attorney General.
There you go.
Okay.
All right. Thank you, sir.
You're welcome, sir.
Get it done as
What
quickly.
happens after that?
Then it'll be made a part of the record, and as soon as an order can be done, you'll get a copy of an order.
All right, sir.
Thank you.
I'd like to just ask one thing, though. I don't understand how come I'm being penalized for their fabrication and taking away my rights. I don't get that part.
Thank you, sir.
You're welcome, Judge.
All right, who is next?
Amari Smith, Your Honor, I think it's the last case. It's number 10 on the calendar.
Okay, they want the next person. I'm done with these folks.
Okay, come on in.
Okay.
Smith. 57.
Man, they said me to have some copies made from the law library, man, sent to them, sent to the Attorney General.
Wait a minute, let me pause this. Let me mute it.
Oh, that was fun. I'm gonna stretch my legs one more time while we're waiting.
Are we taking a break?
Yes.
Yes, ma'am.
Okay. Well, I have Smith whenever you come back on, okay?
All right. Thank you.
Welcome.
No, I know. You still have much?
Assuming yours, I'm assuming yours.
I guess it would, I don't know.
Alright.
I mean, yours probably would. Sorry.
Are you Mr. Smith?
Yes, sir. I'm Mr. Smith.
How you doing, Mr. Smith?
I'm doing okay, sir.
All right, you ready to go with your case?
For the record, I've been sending papers via mail, and I haven't been getting a response. I haven't, before this petition, I sent some papers to Tattnall courthouse.
I don't really see much in the file in those papers. But for the record, they will be noticed.
See, now I filed the petition, but none of the papers in between, I haven't been getting, the papers I filed, they haven't been coming back filed. I just want that for the record.
All right. The record will be noted as to that. As I say, I have the petition, the application, but I really don't have much of it. Well, I do have, don't have much of anything else. All right, I'm going to ask Ms. Smith to give us an overview, Mr. Smith, of the status of this case as it stands right now. I want you to listen closely, and I'll give you a chance to add to or make any comments about whether you agree or disagree after she gets finished. All right?
All right.
All right.
Yes, sir.
Thank you, Your Honor. And we're announcing a limited ready based upon what Mr. Smith has alleged thus far. We think we can travel on the record from the trial and appeal.
Okay.
He is challenging his Fulton County convictions for felony murder and possession of a firearm during commission of a felony. That was from a trial in 2010. They were affirmed on appeal in 2020 in Smith versus State, 308 Georgia 81. He did change lawyers after trial and raised ineffective assistance of trial counsel at the motion for new trial stage and enumerated 2 errors on appeal, challenging his trial attorney's performance. The Georgia Supreme Court found the evidence was constitutionally sufficient. There was no error in denying the motion to sever, and the trial court didn't err in denying continuance request. He has raised, what I understand, are 6 grounds, 2 in the petition and 6 more, or at least additional claims in what he has styled as his own return and answer. In ground 1 of the petition, he alleges void indictment, and we have asserted that's defaulted because it wasn't timely raised prior to trial and on appeal. We've got a copy of the indictment as part of the clerk's record. Ground 2, he just says ineffective assistance of counsel, but he doesn't say what his attorney did or didn't do. And to the extent he's complaining about his trial attorney, he's already had the chance to raise that. In paragraph 1 of his, quote, return and answer, unquote, he said grand jury proceedings were unconstitutional. We've asserted that's also defaulted because that wasn't raised prior to trial and on direct appeal. Ground 2, in paragraph 2, he says he didn't waive his right to be present at grand jury proceedings. That is also defaulted. It wasn't timely raised prior to trial and on appeal. Paragraph 3, he says the indictment doesn't contain both procedural fact and fails to contain all essential elements of conduct and was found in open court. Again, anything about the indictment is defaulted because that should have been raised prior to trial and on appeal. In paragraph 4, he just generally says both his attorneys were ineffective for not disclosing to him the, quote, unrevealed commercial contract agreement accepting liability of charges to a corporate artifice that was employed to have me act as my own legal detriment, end of quote. Whatever that claim is about trial counsel is defaulted, and I think we don't need appellate counsel to address that because that doesn't even allege a violation of a constitutional right in the criminal case. In paragraph 5, he contends his attorneys were ineffective for not challenging venue. that's something that can be, it's anything about trial counsel's defaulted, and that's something we can resolve through looking at what was presented at trial. And then in paragraph 6, he alleges, quote, deliberate deception of a court and jurors in a criminal case by the presentation of non-fault evidence, close quote. But he doesn't say what that is. He says there was a due process violation by the presentation of, quote, false evidence, close quote. Again, he doesn't identify what that is. And then he says 840 non-disclosure, which I have no idea what that is. All that these claims are procedurally defaulted, and we have the record from his trial and appeal to tender at this time.
Do you agree, Mr. Smith, that that's where we are?
I agree that where we are, but it is some errors in there.
Tell me what the errors are.
The errors are that the void indictment. This evidence is illegal. None of my warrants is signed under the no-knock provision. Is invalid. My lawyer is supposed to object it with one of my defendants' attorney. He's supposed to make objections, and he refused to reject. He refused to object to this evidence. None of this evidence was legal. All of this evidence is legal, which made the grand jury procedures. This made me wonder: is the court did I get a fair trial? Or did I just receive a fair trial or not?
All right. The state alleges that these are defaulted, procedurally defaulted. But I'm going to give you a chance to, within reason, tell me why is there anything else to do with the grand jury that you think is a problem for you?
This procedure not done on the minutes. It wasn't, the grand jury procedure wasn't done properly.
In what way?
The face of the records reflect that it's not done on the minutes. The grand jury is not done on the minutes. It's not done in open court. And my appeal, my lawyer who represented me on trial represented me on appeal. So I couldn't argue that. I got no chance to argue that point right there, because the same lawyer who represented me on trial and represented me on this appeal. Until my lawyer just came, Jacob Wren, and he's stressing, well, I'm your new lawyer. We're gonna argue what your old lawyer didn't do. We're gonna argue these claims. He's not trying to argue. He's not trying to help me argue the claims that none of this evidence is valid. I'm telling him none of my warrants is signed under the no-knock provision. None of the warrants are signed. None of this evidence is legal. None of this is done properly.
Okay. Ms. Smith read something, and I think it was number 4, maybe, something about a contract. Can you explain what you mean by that, Tim? Or maybe I misunderstood what she said.
About a contract?
Yeah, about a contract. Did I misquote you, Ms. Smith?
No, Your Honor. It's in the return and answer. He says, it's paragraph 4, page 3. He said, ineffective assistance of both trial and appeal counsels. Trial counsel failed to inquire into the legality of my strength. Both counsel did false representation of matter of fact by words and conduct, misleading allegation, and concealment of things that should have been disclosed, deceived me into an unrevealed commercial contract, agreement accepting liability of charges to a corporate artifice that was employed to have me act as my own legal detriment. Counsel never. Sorry.
Go ahead. Can you tell me what you mean by that, Mr. Smith?
Like I said, I'm just doing this to the best of my ability. None of these, like I said,
We all are just doing this to the best of our ability, Mr. Smith, but I am totally confused about what you mean by they tricked you into a contract accepting responsibility.
yeah, because one of my lawyers represented, okay, the defendant in this case, my lawyer represented to the deceased of this case. My lawyer, I had two lawyers doing trial, Elizabeth Francis and Dennis Francis. She represented, Miss Elizabeth Francis represented Eddie Edwards, which is the deceased brothers in this case.
Okay. So you allege some conflict of some kind, is that what you're saying?
Yes, sir.
Well, tell me about venue. Why do you think venue is improper? You know what venue is, don't you?
No, sir. When I just, the venue as far as the indictment proceeding.
Well, as far as the trial goes, you understand what venue is?
No, sir.
Venue says that trials will be held in the county in which the incident occurred, in which the crime occurred. Venue has to be pled and proven in all criminal cases. You allege that that didn't happen in your case?
I allege that. Wait. But excuse me, come again, sir?
I'll withdraw the question. I'm just curious. Where were you tried?
I was tried in Fulton County.
Did the murders occur in Fulton County? The incident?
Yes, sir.
Okay. Then why do you say that you should have been tried somewhere else? Why do you say venue was improper? Why should they have tried it somewhere else? That's all right. I'm not, I'm just curious as to if you had a real answer to that. Now, I do have one other question, and then I'll let you some things she wants to. But the last item, you say that they introduced false evidence against you. Specifically, what false evidence do you allege?
The warrants is invalid. The warrants.
I'm not talking about the warrants now. I'm talking about evidence that was introduced against you. What false evidence do you claim?
All the evidence, okay, they got a victim, well, not a victim, it was a particular car taken as evidence, but none of the warrants is signed under the no-knock provision. None of the warrants is valid. None of the warrants is executed properly. None of the warrants is signed by a magistrate judge to execute a search on these cars, to execute these searches.
I want to make sure I understand. You're not alleging false evidence so much as you're alleging illegally obtained evidence. Is that right? You're saying they didn't have the authority to do what they did. Is that right?
Right.
Okay. I understand what you're saying now. And I appreciate it. Ms. Smith, do you have anything to supplement the record?
Just the exhibits from the trial and appeal, and Ms. McCandless is going to assist me with that.
Ms. McCann. Is she here? There she is.
Okay.
Play the part of that fight again, I see.
We have the clerk's record from the Fulton County Superior Court is in 9 parts. Respondents 1A is volume 1, I'm sorry, I think we're starting backwards. We'll work, yes, what Ms. McCandless is showing now is Respondents 1A, which is volume 1 of the Fulton County Clerk's record prepared for the appeal.
Okay.
Respondents 1B is volume 2 of the Clerk's record prepared for appeal.
Okay.
Respondents 1C is volume 3 of the Clerk's record prepared for appeal. Respondents 1D is volume 4 of the Clerk's record prepared for appeal.
All right.
Respondents 1E is volume 5 of the Clerk's record. Respondents 1F is volume 6 of the Clerk's record. Respondents 1G is volume 7 of the Clerk's record. Respondents 1H is volume 8 of the Clerk's record. And then Respondents 1I is volume 9 of the Clerk's record. Then there are 11 volumes of trial transcript. 13 volumes of trial transcript. We have those volumes marked, they're sequentially, I think this starts with a bond hearing. I think everything's scanned in, but Respondents 2A through 2M are the 13 volumes of transcripts submitted for the appeal. The way they do it now in the Supreme Court is everything is sequentially numbered, scanned in that way, so it all kind of runs together.
Okay. Mr. Smith, do you have any objection to any of these?
Yes, sir. I object to the, cause I sent in, I object to this, the affidavits. I wanted this to, be for the record, the affidavits, the application of the search warrant.
Okay.
Okay, because I just seen.
Judge, I'm not sure that that's geared to what he's looking at now. I'm not quite sure he gets it.
I don't. He does either. The items that are sought to be introduced are, it's the clerk's record. It exists in the clerk's office.
Oh, okay. Okay.
If you have an objection, you can state it, but the court is inclined, of course, to admit that into evidence. Okay.
And I'm sorry, we've still got a little more, Judge.
That's fine.
Respondents 3 is the transcript of the motion for new trial hearing. And that's on the screen now. Respondents 4 is the appellant's brief filed on Mr. Smith's behalf on direct appeal by his attorney, Jacob Reen.
Okay.
Respondents 5 is a copy of the district attorney's brief filed on behalf of the state on direct appeal. That's on the screen. Respondent 6 is a copy of the Attorney General's brief filed on behalf of the state on appeal. That's on the screen. And Respondent 7 is the reply brief that was filed on Mr. Smith's behalf. And we tender these exhibits at this time.
Those exhibits have been tendered. Mr. Smith, do you have any problem with any of them? As I said, they're a part of the clerk's file.
No, sir.
All right, they're received.
And we have nothing further at this time, Your Honor.
Thank you. Mr. Smith, do you have anything that you want to supplement the record with?
Do I have anything I want to supplement the records with?
Yeah.
Well, I did have some exhibits.
What are they?
Like I was saying, y'all, the search warrants, I would like to proffer to the court, the search warrants, that's made to the records. I sent a copy of these exhibits out to you. I said, that's why I said I haven't been receiving no papers from the court. I haven't, every paper that I sent to the court, I don't receive them. My room flood out. I haven't received any papers from the court. I sent exhibits.
All right.
I wanted to proffer to the court the search warrants.
All right, anything other than the search warrants?
In the second order for the judge, okay, the judge, she dismissed some motions I filed pro se. It's the second order dismissing defendant pro se motions.
Yeah.
I wanted to make that exhibit because it shows at the bottom the record's not whole.
All right. Then you will need to make copies of those, send them to the clerk's office here in Tattnall County, and send a copy to the Attorney General's office.
I did, sir. I made a copy.
I'm ordering that be done now as a part of this record, okay?
Okay.
All right. You have the address for the Attorney General's office. Get it done within the next 30 days. They'll have an opportunity to object to anything that they think is inappropriate. Anything else, Mr. Smith?
No, Your Honor.
And anything else, Mr. Smith?
No, sir.
All right, thank you. Have a good day.
And I think that's it, Judge, at least from my list.
Is there anything else? Rachel?
We're finished.
All right. Thank you. Good to see y'all.
Good to see you too.
And